little late in seeing all the tags. I'm very tired. But let's talk about that crazy Disney Plus story, and why I think that underlying issue with the arbitration clauses is probably headed for the Supreme Court in the not too distant future, which is also probably why Disney dropped it. So last week, Disney finally dropped its argument, likely among all of the backlash online, that the court should dismiss a wrongful death lawsuit filed against Disney because that family had signed an arbitration clause on Disney Plus. To be clear, the wrongful death occurred in a restaurant in Disney Springs, and Disney Plus is a streaming service online. But here's the thing. The statement emailed to the Associated Press. Theme Park Division did not say, hey, this is not a valid argument anymore, so we're going to stop it. Instead, they just said, we're going to waive our arbitration rights and let the lawsuit proceed. You waive your arbitration rights. What you're essentially saying is, hey, I know that I still have the right to do this. I'm just not going to do it. And a lot of people, including many on this app, are pretty confused because our logical brain says, that's ridiculous. How can I be told I need to go to arbitration for something that occurs in something entirely different just because it's the same operating entity, kind of? And the answer to that lies in the Supreme Court around 2010, because that is when we saw a slew of pro-arbitration rulings. It gave the act of arbitration a whole lot of proverbial teeth. To be clear, arbitration as a general principle is not necessarily a bad thing. Courts are incredibly overwhelmed. File a lawsuit right now, today for instance. It could be a very long time before you actually got your day in court. Arbitration as a general principle is supposed to ease that burden. Not only as much less time consuming, but actually a lot cheaper too. Except that a whole lot of companies with a whole lot of lawyers figured out some pretty not so difficult ways to turn arbitration in their favor. Ended up with two concepts: mandatory arbitration and what's known as infinite arbitration clauses. Mandatory arbitration. Most services you sign up for, you just need to click a little box that says, I agree to the terms and conditions. Sometimes we've even gotten sophisticated now, and it's like, I also have to click this box to say I read the terms and conditions. We all sign it. We don't all read it. But in those terms, a lot of times, is something about an arbitration clause. Again, in case it isn't clear, is essentially giving up your ability to bring a case before a judge or a jury. And many of these are called mandatory arbitration because there is no little box to click that says, I agree to the terms and conditions, except for the arbitration clause. I'm gonna cut that out. Either agree or you don't agree. You either get to use the service or you don't. Mandatory arbitration clauses have many of their own problems. The more recent trend of infinite arbitration clauses has even more problems. Essentially, and typically, a mandatory arbitration clause that companies or entities then try to use to bind you in an entirely different circumstance to arbitration. For instance, a streaming service and a theme park death. What many people don't know is that many of us have agreed to some sort of an infinite arbitration clause with at least one company, probably 5 to 10. While some lower courts have disagreed on this expansive use of arbitration clauses, many, if not the vast majority, have basically said our hands are tied. Because while many judges and courts really do look at situations like this and think, that's preposterous, court precedent says that federal arbitration law requires courts to enforce the arbitration clauses according to their terms. Also typically include a provision saying only an arbitrator can decide whether a claim falls under arbitration or not, meaning courts can't even make that initial decision in a whole lot of instances. And the worst part about it is a 2019 decision from the Supreme Court made it so that class action lawsuits are invalid unless the arbitration clause specifically allows for them, which doesn't happen. Since many claims that would otherwise fall under mandatory arbitration don't have a whole lot of damages, you often need a class action to be able to justify the lawsuit and to have lawyers actually be able to take the cases. For example, if one person is suing for $100, not really an impact. You're going to lose more money by taking it to court. But if there's 50,000 people suing for $100, yeah, okay. Arbitration clauses now make that pretty much impossible. And probably within the next year or so, I think we'll see a more expansive definition from the Supreme Court about what an infinite arbitration clause can actually cover and what it can't. Because we are starting to see some circuit splits, which is essentially when federal courts decide different things. Since the Supreme Court likes federal law to all be, the same interpretation, they're probably going to take it up. That circuit split arose, by the way, from the DirecTV issue and clauses involving telemarketing calls. Subsequent ownership of DirecTV by a parent company who had an arbitration clause in place. Before it hits the Supreme Court, it's likely that we're going to need a perfect case or a perfect plaintiff to be able to bring a challenge. And oh, by the way, this lawsuit brought against Disney was in Orange County Circuit Court, which is a federal court. So my guess, although completely unfounded obviously, is that Disney looked at this and said, this might be the case that ends us up in a really bad spot in front of the Supreme Court. And we don't want to do that. So we'll just take this one as a loss and keep doing what we're doing everywhere else.